African.
Live from the Cactus Creek at Ibri, he is the king of prime time, Ghana's undisputed entertainment laureate, and still the youngest old man in Ghana. Put your hands together, show some love for the indefatigable KSM.
The KSM Show.
Thank you. Well, we're back again for what I call the most anticipated show. So some love for that. Well, you know, my good friend Tsatsu was with us some time ago. 2 weeks ago, right? Before he came, I was really eager to just go into this court case thing. And he said, listen, the judgment is not out there, so I can't comment on the court case. Of course, we still had a great show, and we got to know the man behind the court. You know, we saw Tsatsu up close and personal. But now the judgment has come in, so we are inviting him again. And this time, the first one was, let's chat with Tsatsu. Do you know the name for this one? Tsatsu in the box, man. Show some love. No, I'm going to put him in the box, and I have a few questions to ask him, so it's going to be fun. In the meantime, put your hands together, show some love for my good friend, Dr. T. Tsatsu, welcome again.
Thank you.
You're back at the creek.
I know, it's a beautiful creek, a great setting, and I'm glad to be back.
And I'm glad you're back. And I see you have books this time because you're ready to be inside the box.
I know, but actually, it's very comfortable to be in the box if you're committed to the truth. And if you're committed to justice, and so I don't have a problem being in the box. Don't worry about that.
You have no problem. Tsatsu in the box, man. Stick around. We'll be right back.
The KSM Show.
Located in the calm green hills of Ibri is Ghana's best kept secret. Cactus Creek, a peaceful haven on the mountain, your home in Ibri. Plush rooms, amazing landscapes, sizzling dishes, indoor and outdoor entertainment. Looking for the ultimate serenity? Don't look any further. Call Cactus Creek on 0550-395-007 or 0507-338-158. The best decision you'll ever make. Welcome home.
Pulse Fitness Center, the premier destination for fitness in Ghana. Meet the indefatigable captain.
There are 3 things that I love doing. Number 1, workout. Number 2, workout. Number 3, workout. Workout put mind, soul, and body together.
The captain has spoken.
We're getting busy. Bright lights, yeah, they make me dizzy. Logo Liggy. I just want the Lizzie. It's a Logo Liggy. Uptown, chasing for the Lizzie. Downtown, everybody busy. Logo Liggy. Like me, Logo Liggy. I just want the
Pulse Fitness Center, East Legon Branch, Lizzie Sports Complex, Cotton Street, East Legon, Accra, Ghana, 0302 519 675. Kumasi branches, Officers Mess Branch, Denyame, Major Kobina Drive, Kumasi 0541 871 602. Golden Tulip, Kumasi City Branch, Rain Tree Street, 0322 492 647. Pulse, the premier destination for fitness in Ghana.
Say what lie we for around town.
Your friend me keki me a taxi driver. Chawo kai titi taxi driver. Wa kona humi jemu krano. Me ano di na chija me na e futu kakra di jam nso ne say. Say e ba ne battery dia ke speed Speedmate battery. Then only battery papa. You see this whole area? I'm the original chef to Kabarat. Now pay biamenya biama. One director no park was here. Last time the battery call off, me sorting out one time. Saka no battery ni buajuma all right. Nice one. Mention fix. Saka alaji. Okon cross course anyama bay. Taranya no shamian. Oh, kahaji ayen to save you. And so shamian is sorting out with Speedmate battery. And I just say, Hasabri na sem koguya. He say what just too much talk about hundred. May come full Speedmate batteries. Had the amount.
Minuanum, we hear battery papa dia. A Speedmate battery.
Uko rata moto say na accredited agent. You gonna have fun after bia. Ubenya biato. Battery papa no.
The KSM Show.
We're back. And just in case you missed, when I told him I'm glad he's back, and today he's in the box. He said he's cool with being in the box, man. He says if you have the truth, then the boss doesn't scare you, man. Show some love, man. My first question is this, Tachu. The first court case, that was 2013, eh?
Yes, the election petition
2013. There were 6 judges?
Nine.
And you are taught 6.
5 of them were my former students.
Okay.
Yeah.
I'm setting something up. That makes me a lawyer. So the first one, 5 of the 9
were my former
were former students.
Right.
In this petition, all of them were former students.
That is true.
Including the Chief Justice.
That is true. That is true. Yes.
Okay.
Yes. That is true. So whether they were 7 or 9.
7 or 9.
Yes. But they were my students a long time ago. This time, they are justices of the Supreme Court. And it's very important to remember that, because when I appeared before them this time, I was appearing as an officer of the court, a lawyer who is advocating a case before them. And that's an important difference. I wasn't there as their lecturer. That's 30 years ago or 20 years ago in some cases. So I think we should forget about this lecturer business.
I'm glad it has come up, because some said, and many, not just some, that, you had taught them all. So you had the attitude that, look, this is your former lecturer. But you're saying it had nothing to do with it.
It had nothing to do with it. And I'm very conscious of the fact that, yes, I've taught a lot of people, not just judges, people in different positions, but they have all moved on and become something in their own right. I was taught by many people in the past. I mentioned some of them. But, I have also moved on. These people have moved on. They become justices of the Supreme Court. So I'm very conscious of the fact that when I appear in these cases, I'm not appearing as a lecturer or former lecturer. As I said, I'm appearing as an officer of the court. That's what lawyers do. We don't appear as supplicants trying to seek favors from the judges. We appear as officers of the court trying to help the judges arrive at justice according to the law. Because justice according to the law requires that, the court process enables all the elements of the law to be put before the judges by both sides. So each side is not just seeking a favor, because this judge used to be my student, he should decide for me, or because this judge is my relative, he should, no. We go there and each side is presenting their case and backing it with the legal arguments, with the authorities, the constitution, the precedents from past decisions and so on. And that's a serious business when you think about it, you see, because I think we underrate what is at stake when a judge is having to listen to arguments and make a determination that is supposed to be an unbiased, objective determination about the case that has been brought before him. You see,
So basically, as an officer of the court, yours is to present a submission on whatever side you're speaking on, so that the judges can listen to both submissions from different parties and make a great decision. That's what you're saying.
Absolutely.
So that's all you were doing.
And you see, because you're dealing with legal matters, even though sometimes people say the law is in the bosom of the judge, it's not quite like that, because it requires referring to a lot of material. For instance, when we talk about the common law in relation to, say, Ghana, we're talking about cases that have been decided. Some were decided in England centuries ago, and they still have some relevance. Some were decided more recently. And lawyers, you know, try to uncover all this material and make it available for the judges. Because without that, the judges will also be handicapped. You know, and that is why, for me, if you want to be a good lawyer, you really have to be an ongoing student of the law. You have to remain a constant student. So even as judges, I'm sure they themselves recognize the value in constantly refreshing, you know, their knowledge and their understanding of the law. Certainly that's my attitude. And so when I go before judges, whether they be my students or not, I go before them, you know, seeking to bring to bear, in the case that I have, whatever material I believe can be helpful for their appreciation of the legal issues at stake.
Okay.
And I have to say that I'm, you know, determined to advocate in the most effective way possible for them to see that what I'm presenting is backed by the law. It's not from my imagination. And that's why we cite a lot of material from legislation and so on and so forth to the courts.
Okay.
So forget about the students.
Okay. So we get it now.
Ancient history.
That was ancient history. They were not there as students. So, but you have people talk about, they call the whole courtroom the law faculty with a lecturer. All of that is baseless.
I think you know, I mean, that is sort of humor for some people.
Yeah.
And that's fine. People can be, you know, taking their light-hearted moments even about court proceedings, because otherwise the whole thing will look too serious. You know, so we've got to have a bit of light-hearted humor.
I hear you. So based on what you've said, based on the conclusion that you're there as an officer of the court to help actually the judges in whatever decision they are making, how did you think you performed in terms of how much of an impact were you able to affect the judges in their decision making? Can you assess yourself and be based on the judgment they came up with? Did you think you were helpful?
Well, I think I did provide as much help as I could. So, you know, one of the things that I think people miss about the judgment that was delivered was that the court decided that the preliminary objection to the case that was brought by the petitioner, President John Mahama, the preliminary objection that they raised to the effect that he did not even have a cause of action. The court decided that that was not right, and that John Mahama had a cause of action. In other words, legally, what he brought before the court could not just be thrown out as a preliminary matter. So I have to say that in that respect, we achieved a very important big step. You know, I have to start with the big step before I talk about any steps backwards. Now, as far as the judgment itself is concerned, I don't think there's any question in my mind that the effort that we put in to bring across very important, vital issues to the court, that effort was very worthwhile. The fact that the decision went against us is part of the reality of court proceedings. In my own estimation, there are a number of aspects of the decision that are somewhat strange. And let me give you a couple of examples of what I mean. You see, in deciding on that preliminary objection that I talked about, the court said that the matter has to go to trial. The cause of action, you can't rule it out that there is no cause of action. The matter has to go to trial so that based on evidence, you can determine what is the legally correct position as far as this election is concerned and so on and so forth. So we now go to that next step and we're looking at the evidence. And something very interesting happened in the judgment, which I don't think that we can justify legally. You had a situation where the court, tried to set aside the evidence of two of the witnesses that were presented by John Mahama, Dr. Kwesa White and Robert Joseph Metal-Nunu, otherwise known as Rojo. Now, there was a description of that evidence as fanciful tales, which is quite extraordinary in my mind, because here were two witnesses who gave a completely truthful and compelling account of the situation in the Electoral Commission premises on the day when the declaration was supposed to be made. They talked about what was happening in the so-called strong room, the interactions they were having with various officials. They talked about the fact that the chairperson, who was the returning officer for the election, she was hardly ever there. She showed up once or twice and so on. And then importantly, Mr. Metal-Nunu particularly gave a very vivid account of the interaction that he had with her. And based on that interaction, according to Mr. Metal-Nunu's evidence, he and Dr. Kwesa White had to go on an assignment to go and brief their candidates, based on what they were told by the chairperson. By the time they got to the candidates, she was already making a declaration. Now, the case that we put forward is clear. She had not even begun to do her duty according to the law that she herself was signatory to, the constitutional instrument which requires her to be the person assembling and collating the results from the regional collation centers, and in the presence of the candidates' agents, raising with them whatever, or sorting out whatever issues they had before making her declaration. She had not even begun to do that. So, based on the evidence of these two witnesses, how can anybody say that there was even a valid declaration according to her own constitutional instrument? Now, so trying to kind of dismiss the evidence of these people as fanciful tales is actually really very strange to anybody who is being objective about the matter. Now, on the other side, the respondents decided they would not give any evidence. So if they wouldn't give evidence, what is there to counter or to contradict the evidence that we put forward? Now, you have the evidence of also Mr. Johnson Asiedu Nketia, and some elements of that evidence were being turned into directions which, in my view, were not justified based on the totality of the evidence that he gave. But you see, fundamentally, I think what I think is most problematic about the judgment is that we have a situation in this country now where if you base yourself on the declaration that was made by the chairperson, as we all heard it, the numbers that she gave, there was not a constitutionally valid declaration because no candidate got 50%. Mr. Nana Akufo-Addo got 49.625 based on the numbers that she herself announced. Now, what the court then said was that the next day there were some corrections issued by the Electoral Commission. But those corrections were not by the chairperson, the returning officer. They were unsigned press releases. Even more important, the numbers in those corrections were different from the numbers on which the court was basing itself as the results
yeah.
of the election.
Yeah.
So you have a lot of problems about these numbers, and really the only person who can speak authoritatively to those numbers is the chairperson of the Electoral Commission. But she never was in the box.
So we'll get to that. Based on everything you've said, how wrong are people when they say the law is in the bosom of the judge then?
Well, you know, I think that's just a sort of metaphorical way of expressing the fact that ultimately it is for the judge to make a determination. Yes, so something comes out of the bosom of the judge, which is the determination of the case. But if that determination is not based on the evidence that is before the court, if it's not based on the legal principles, and in this country especially, we're talking about the Constitution, which is the fundamental law of the land. So if the Constitution says that for a person to be declared president, he must have had 50% plus of the total valid votes cast. And we hear a chairperson who is an authorized returning officer give numbers which don't lead to the 50% plus, then we have a problem, because then effectively we're going against the Constitution and we're setting a really dangerous precedent for the country.
I want to speak it from there, saying that we are setting a clearly dangerous precedent for the country. That's what you just said.
Well, that's what I said, and that's really important because...
But this is a decision that has been arrived at by judges.
Absolutely.
So are the judges...
Unanimously.
Unanimously.
That is correct.
So are they setting that dangerous precedent?
I believe so. And as I said, we put forward before the court arguments of law as well as statements of fact backed by evidence which supported why we were insistent that based on her own declaration, her own data, and that was really never contradicted, that based on her own data. So what we ended up with as a result that came from the judges was based on a supposed correction. But as I said, the correction was not made by her. I mean, clearly it wasn't made by her. It was unsigned. Maybe being a press release, it may have come from the new ambassador designate to Denmark. You know, maybe it was her work. But, you know, it was not by the chairperson of the Electoral Commission. And it had numbers in it that are inconsistent with the numbers which the judges were using as the basis for the decision. So that's a problem. And that's why I would humbly say that it sets a dangerous precedent, because what it means essentially is that in any future election, you can have a chairperson, the returning officer, come and make an announcement with numbers which nobody can really explain, and those numbers do not really lead to the constitutional 50% plus, and then later on she comes and says, well, there was a mistake there. There's no explanation as to how the mistake occurred. Even in the correction, the numbers are different. I mean, you ought to just look at the press release and set it against the numbers that the judges pronounced upon as the numbers on which this election, should be determined. They're different. In the so-called correction, even the number that they quoted as the number that had been pronounced by Mrs. Jean Mensah was different from what she actually pronounced, you know? So there's a lot that required explanation. And unfortunately, she decided that she would not give any explanation to anybody.
The whole Ghana was actually waiting for you to get her in the box. And if she had stepped into the box what are the key things you wanted to know from her?
You know, I'm not going to tell you all the things that I would ask her in the box because there can still be opportunities for her to be in the box.
Okay.
According to the decision that even the judges gave, there's some things that can be raised even in a high court case because, you know, there were issues about Article 23 of the Constitution, the duty for her to act fairly, which is a duty that the Constitution imposes on all officials, you know, in any administrative capacity. Now, when we put across the fact that she had not acted fairly, what the court said is that that is a matter that has to be taken to the High Court. So, if anybody decided to take that matter to the High Court, for instance, I guess she'll still have to go in the box. but you know, my simple point is that if you have a constitutional matter like the duty to act fairly coming up in the context of an election petition, again, it is very surprising in terms of some of the precedents that we are familiar with for the judges of the Supreme Court to say unanimously that that is a matter that should be sent back to the High Court. What the precedents that we are familiar with, some of which we quoted, what they show is that as soon as a court like the Supreme Court sees that there are matters coming before it which have to do with compliance with the Constitution, that's something that they have to sit up and check on and make sure whether indeed the Constitution has been complied with or not. So leaving it and saying that should go to the High Court, again, was not consistent with certain precedents which we cited to the court, precedents which show that the court should always try to ensure that the Constitution is obeyed. The Constitution is the supreme law. It is what binds us together as a country, as a people. And the Constitution's authority resides in the sovereignty of the people. These are very weighty words that the Constitution itself has. That's why I brought the Constitution, you know, because these are not things that we take lightly at all. The Constitution, in its very opening words, says the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government are to be exercised in the manner and within the limits laid down in the Constitution. So it is a serious matter. And then it continues, this Constitution shall be the supreme law of Ghana, and any other law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void. That's why I said that judges, whenever any issue of acts against the Constitution comes up, they naturally have to sit up.
How do you answer this though? Because from what you're saying clearly, certain things went against the Constitution, as you're saying. But there was the other party too.
There was
using the same Constitution. And they are also basing theirs on that same Constitution.
Yes.
So how do we deal with that?
Well, this is exactly the point. This is why in any dispute context, judges have to assess the weight of arguments that are made before them, and they have to show a fidelity to the Constitution. You know, a lot of people make the observation that, you know, sometimes judges who are appointed by one president, they tend to favor that president as against cases involving other people and so on. Now, when judges are appointed by whichever president, they swear a judicial oath, and that oath makes them responsible not to whoever appointed them, but to the Constitution. And they really have to live by that. It's not easy because as human beings, people have their political preferences and so on and so forth. But ultimately, when you are appointed to that position as a judge, you have to rise above whatever partisanship you have. I mean, many people know some of the political loyalties of judges before they became judges.
We're getting into a very, very, very interesting arena. We'll take a short break. When we come back, we are picking it up right from there. Stick around, folks. We'll be right back.
The KSM Show.
Located in the calm green hills of Ibury is Ghana's best kept secret. Cactus Creek, a peaceful haven on the mountain, your home in Ibury. Plush rooms, amazing landscapes, sizzling dishes, indoor and outdoor entertainment. Looking for the ultimate serenity? Don't look any further. Call Cactus Creek on 0550 395 007 or 0507 338 158. The best decision you'll ever make. Welcome home.
Your friend me Keki, me a taxi driver. Chawo kai titi taxi driver. Wakona humi jemu krano. Me ano di nechi jami. Na e futu kakro di jami nsu ne se. Se e bani battery di ake. Speed mate battery. Na no ni battery papa. You see this whole area? I'm the original chef to cabaret. Na pe bia menya bia ma. One director no park was here. Last time the battery call off. Me sorting out. One time. Saka no battery ni bo adwuma all right. Nice one. Mental fix. Saka alaji. Okon cross anyama bayi. Daro nyame no share me out. Oh, kahaji ayen to save you nisu. And so share me I'm sorting out with speed mate battery. And I just say, hasabri na sem kogu ya. He say wa ja too much talk about hundero. Me can full speed mate batteries. Head the amount.
Minuanum. We hear battery papa dia. A speed mate battery.
Uko rata moto say na accredited. He just wa Ghana have an up bia. Ubenya biato. Battery papa no.
Paul's Fitness Center, the premier destination for fitness in Ghana. Meet the indefatigable captain.
There are 3 things that I love doing. Number 1, workout. Number 2, workout. Number 3, workout. Workout put mind, soul, and body together.
The captain has spoken.
We're getting busy. Bright lights, yeah, they make me dizzy. Logo liggy. I just want the Lizzie. It's a logo liggy. Uptown, chasing for the Lizzie. Downtown, everybody busy. Logo liggy. Like be logo liggy. I just want the
Paul's Fitness Center. East Legon Branch, Lizzie Sports Complex, Cotton Street, East Legon, Accra, Ghana, 0302 519 675. Kumasi branches, Officers Mess Branch, Denyame, Major Kobina Drive, Kumasi, 0541 871 602. Golden Tulip, Kumasi City Branch, Rain Tree Street, 0322 492 647. Paul's, the premier destination for fitness in Ghana.
say what lie we for run town.
The KSM Show.
We're back. We have the man in the box, and for the first time we are hearing what he really feels about what everything that has transpired in his view has been. Tsatsu, you talked about how it's a human institution, and there are talks that maybe when a particular president appoints certain judges, there may be affiliations here and there, but they are not supposed to. They're supposed to look at the law and the justice. How realistic is that based on what we have been through? What is your take? Do you think that they have what you have witnessed is the law at work, the law in action?
Well, you know, I think that it's really something which each person has to answer according to their conscience ultimately, because what I was trying to point out is that once you are appointed, whoever appointed you, you swear an oath to uphold the Constitution and the laws of Ghana. That's what you are supposed to do as a judge. So you don't swear an oath to decide for this party or that party or for this president who appointed you or whatever. But as I said, we're all human beings. We know the extent to which, you know, human beings can be affected by biases one way or the other. And we've seen over the years, I mean, I've been in practice many decades, and I've seen the extent to which, you know, judges make a lot of effort to ensure that they are making decisions in accordance with a principled position based on the Constitution, based on the law, and so on. So, for instance, when I make the points that I make about the fact that certain pronouncements of the judges do not seem to me to be consistent with the Constitution, I'm making what I believe is a legitimate observation about this particular case. I'm not trying to attribute any motivations to them, because that's a more difficult, it's a more complex issue. But in terms of my simple observation about what the role of the chairperson of the Electoral Commission is, what she actually did, and what the consequences of what she did are for the country, I must honestly tell you that there are many problems with the decision that the judges gave, you know, last week, because you do have this situation where even the counsel for the Electoral Commission actually questioned Mr. Metul-Nunu and said, you were waiting for 3 hours in the secretariat of the chairperson of the Electoral Commission, which means that she had not been there for 3 hours before the time when she was supposed to come and declare the election. Where was she? We are entitled to ask. Where was she in those 3 hours? She then comes back to the office, has a meeting with Mr. Metul-Nunu, in which Mr. Metul-Nunu is raising some important concerns, and then she asks, or she requires Mr. Metul-Nunu and his other colleague, Dr. Professor White, to go and talk to their candidate. By the time they get to their candidate, she's already on air making a declaration. So when did she do the work that she was supposed to do as the basis for making a declaration? It didn't happen, because all the evidence that was before the court showed that she was barely in the strong room over those 2 days after the election, the 8th and the 9th.
Unless she was doing the work somewhere else for the 3 hours.
We need to know that. We need to know that, because the legal requirement is that she should do it in the National Collation Center. That is Regulation 4410 of a constitutional instrument which she herself signed, CI 127. You know, so she can't do it somewhere else. You know, and
well, there were 3 hours. So
according to her own counsel, not even, you know, Mr. Metul-Nunu said he waited for a significant time. It was her own counsel who said, you were there for 3 hours. and that itself actually undermines the case of the Electoral Commission even more significantly. And yet none of that was taken into account. You know, and what I'm insisting is that these are matters of law and of the Constitution, because ultimately we cannot have in this country a president who is there without having received 50% plus of the valid votes cast in an election. That's just a no-no according to the Constitution. And I believe we've had many elections over the years. Even in this Fourth Republic alone, we've had election upon election. We've had different you know, chairpersons of the Electoral Commission, Dr. Farijan. We've had Charlotte Osei. I mean, at no point have we had to face this situation where numbers are announced, then the person who announced them herself doesn't come and say, oh, I'm sorry, I need to make a correction of those numbers. And I, did not quite read something right or whatever. No, some press release is issued without a signature, and the numbers in the press release are themselves different from both the numbers she pronounced and also different from the numbers that the judges used to make their decision. That's not a great place for Ghana to be in. And if I were to be announced as victorious on account of ever-changing numbers, I would be very concerned about my own situation.
So, great, but I just want to skip to some of a few things during the course of the trial that came from you. I know you were saying things seriously. Were you trying to lighten things up by like asking about a certain bridge and who put the bridge? What happened to the bridge anyway?
Well, I think the bridge was removed.
Oh yeah.
Because no, but it was a serious discussion.
Yeah.
The bridge issue came up when we were trying to ask the court permission to serve what are called interrogatories on the Electoral Commission. Interrogatories are just questions. And the questions are meant to be served so that you narrow down the extent of the dispute between the parties. So if you ask certain questions, they give answers, then some of those answers, they reduce the kind of dispute that exists between the parties. Now, we were not allowed to have the interrogatory served on the Electoral Commission. And during the discussion in court, one of the judges asked me, but aren't you trying to cross a bridge that you have not got to? In other words, she was suggesting that when it gets to the time to cross-examine the witness from the Electoral Commission, that would be the point where I can ask some of the questions which I was trying to ask in advance. And so I had to say to her that I didn't put the bridge there. You put the bridge there. In other words, you are saying that you want us to wait to cross-examination. We have proposed that these questions should be asked before so that we don't actually have to ask them again because they are not in dispute anymore if you do that. But what was also interesting was that at that point, the court had said that the questions that we posed in the interrogatories were not relevant. So then I asked the question, in any case, if they are not relevant as interrogatories, how can they be relevant when it comes to the cross-examination? In other words, when we cross the bridge, we'll find that we are not allowed even to get to the other side. But as I said, in the end, the bridge was taken away. So all that I'm left with as far as the bridge is concerned is that I've seen that some people have made T-shirts about the bridge.
Yes.
So I'm going to ask for royalties from those people so that I can...
I saw on TV. I'm going to cross the bridge.
At least I can earn some income from the T-shirts. Oh, yes. But unfortunately, the bridge was no longer there.
Yeah.
But one of the interesting observations that I saw, from some of the people who were, making light-hearted remarks about the bridge and so on, is quite a serious one. They said, we need to cross that bridge together as a nation. We need to cross that bridge together as a nation. I thought that was a really profound, even if light-hearted remark, because indeed, as a nation, we really need to examine all these legal issues around, what the Electoral Commission is doing, when it does it, how it does it, and so on. Because essentially, what we are faced with, again, if we are not careful, if we just take some of the positions that the court took in the end, which were against us. We lost, the argument on some of those things. But what we are faced with is as follows. An electoral commission with a constitutional responsibility to conduct the elections. They are the only ones with that constitutional responsibility. They conduct the elections. A chairperson with a constitutional responsibility to make a declaration. When it comes to asking them questions about what they did, especially for the purposes of a court setting, we can find ourselves completely disabled from asking questions. In 2013, in the electoral petition in 2013, interrogatories were served on the Electoral Commission. They were allowed to be served on the Electoral Commission. And the Electoral Commission provided answers to those interrogatories. So that was a precedent from 2013. We relied on that precedent. And you know what the court said? At the time we made that argument, the court said, in this case, because we have a short time duration for the hearing of this petition, we are not going to allow this preliminary process to take place. Now, the new rules that they cited, which set the time frame for this petition, those new rules do not say that you cannot have interrogatory. They don't say that. They don't also say that because we have a short time, those preliminary processes are no longer part of the normal legal process. But the court came to a decision that we are not going to allow that. Now, in the end, interestingly, the amount of time that was spent in legal arguments about the interrogatories and so on was much longer than the time that it would have taken for those interrogatories to be answered by the Electoral Commission. So you ask, what precedent is now being set that the Electoral Commission is not allowed to be served with interrogatories, which means that in a future case of this nature, again, it can be argued that they will not be served with interrogatories. Of course, the judges can decide differently in the future because, again, under the Constitution, the judges can decide in future that what they said this time was not right, and they can change their minds. And sometimes judges honestly do that. And that is what sometimes when we went on review, we were sometimes asking the judges to change their position from what they had decided when they were 7, and we were saying that when they are now 9, they should re-look at the thing based on the law, based on the Constitution, and recognize that they had been wrong. But it's not easy to recognize that you're wrong.
Yes. Show some love, man. we are sort of winding down, but I still want to get to the crux of this because, you have explained everything, very flowery, deep stuff. The point is, none of your applications were accepted. Does it make you feel like, what to sing, you failed somewhere, you didn't deliver properly somewhere?
No.
What does it mean?
No, not at all. I think that I tried to make this point a little bit earlier that we as lawyers, we do our best to advocate based on our knowledge of the law, what we understand to be the precedents, the Constitution says, the statute says this. So for instance, we argue a point based on the law of evidence, the Evidence Act of Ghana. Then the judges come, they give a decision based on Black's Law Dictionary, which is an English law textbook. And frankly speaking, what is in that English law textbook is different from what is in our statute. Now, even if the judges still insist that what is in that English law book is what they are applying, we will still respectfully say that we think they are wrong. Now, it doesn't make us arrogant because, in fact, the evolution of the law shows that sometimes decisions that were once thought to be right are later on changed and thought to be wrong. And so I am convinced that in time, some of the decisions which I'm suggesting humbly are not right, that were made by the judges about interrogatories and so on. They're decisions which will ultimately not stand the test of time. That is my conviction about some of those decisions. And I think they won't stand the test of time because when you look at the framework of the Constitution that we have and the way in which that framework seeks to make public officials accountable, it's difficult to square that constitutional framework with decisions which just put a shield, a cordon around public officials and does not enable them to step forward to give an account of what they've done. So I think the whole constitutional framework that we have seeks to enhance accountability of public officials. That's a very important underlying principle. And therefore, if you have decisions that do not advance that, then I would think that in the long run, they will be seen as aberrations.
It won't stand the test of time.
They won't stand the test of time, in my view. But we'll see. The test of time is a long time. And we may not be around then, but you can be sure that
Talking about the
Black's Law Dictionary,
Yes.
you know, I can't forget that because it was for me an important time in this case because the terms of the Evidence Act are very clear, and they are very clear in the opportunity that they give for us as the petitioner or as a party in the case. They give us an opportunity to call the Electoral Commission chairperson to give evidence. It's very clear. Now, what the judges were using from Black's Law Dictionary was a procedure in the English common law context, which is quite different. And our Evidence Act is also very different from, because the English common law has also developed, you know, along similar lines. But our Evidence Act is very clear. I mean, anybody reading, I mean, the law is often just English language put together. So if you just read it, you can understand it. I mean, so when it says that we may call the witness of the adverse party an adverse witness, we may call them as a witness. It's not talking about when they are giving evidence in the witness box, which is what Black's Law Dictionary talks about. So, you know, respectfully, I will just say that Black's Law Dictionary doesn't bind the people of Ghana. What binds the people of Ghana is the Evidence Act, which is part of the law of Ghana.
You seem to have an, I don't know whether the right word is obsession about the Constitution. And when you are standing up on your feet for 2 hours, is it that passion that drives you, that, should I call it like an insane obsession to see justice? Because,
you know, I think you're right in your choice of words. It is an insane obsession. Ever since I started practicing law from the 70s, when I was in my 20s, and I was advocating on behalf of people like I mentioned the last time, Pa Willie and so on the basis of human rights. At that time, we didn't have a constitution, but we had laws on the basis of which we were advocating their freedom. We were advocating that they were not being kept in jail by a legally appropriate method. Now, we would argue that, and sometimes in those days by a military regime, they would just sign an executive instrument in order to try to validate what had been done previously without any legal basis. Now that we have a constitution, for me, there's really no excuse to go back to those sorts of experiences where, you know, I mean, the executive and judges could do certain things which you could not question because there was no higher legal framework. But we now have the Constitution. And that Constitution, as I read to you, embodies the sovereignty of us, the people of Ghana. not only does the Constitution embody the sovereignty of the people of Ghana, but what the judges are doing, which is administering justice. The Constitution again tells us in very clear language, Article 1251, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to the Constitution. So again, you get the point I was making earlier, that these judges are supposed to be independent of whoever appointed them, subject only to the Constitution. And so when I advocate on the basis of the Constitution, that is because for me, that is what the judges are ultimately subject to. And I find it important to bring that to their attention in as forceful a manner as possible. So if a 70-year-old stands up for 2 hours on that basis, that's because he is energized by the Constitution.
Energized with the Constitution. Let me just flip it just for a second in our dying minutes. Let's say it's the NDC in power. We have gone through the election and the numbers have come up and they seem like what you're saying now, not too understanding, a little bit, and it favored the NDC. Would Tsatsu crusade like this and still fight and say this is wrong?
Absolutely. Absolutely. I can tell you. The passion, the insane obsession, as you rightly described it, that I have for the protection of the Constitution would make me insist that the right thing should be done. No question about that. And really, I do want to illustrate this by something real in my life and in the life of my family. You know, after all that I went through in terms of, you know, the decision to throw me into jail and so on, after all that, which I knew was not in accordance with the Constitution, was not legally right and so on, and I was fighting and my wife was campaigning on my behalf and so on. When President Mills became president of Ghana, I can tell you one of the first conversations that my wife and I had with him, and may he rest in peace, and I'm sure he will not mind my talking about this publicly. One of the first conversations we had with him was when I was saying to him that, you know, what happened to me should not happen to anybody. And I would not like to see that happen under his regime. I would not like to see that happen. And you know what my wife added to him? My wife said to him, and I mean, you know, in a respectful manner, but in a firm manner, he said, you know what? If that happened to anybody, I would be in the streets campaigning against you if it happened to you. And truly, I think that is a common insane obsession that we have. Because
we have that in common, eh?
Yes, we have that in common. And I think that has driven a lot of my life in the legal sphere. You know, I do have you know, a commitment to not only seeing the Constitution enforced and applied in every way possible, but also an obsession about human rights. You know, from those earliest days in the 70s, the cases that I was advocating for were about the rights of people. And those are perspectives that I have never lost sight of. So for me, being a lawyer is not really just like a day job or, you know, just something you do to earn a living. Being a lawyer is also about having a sense of mission in the profession that, you know, God has enabled my talents to put me in. You know, God has endowed me with talents. I'm in a certain professional context. I must use those talents to ensure that I glorify Him and to ensure that I serve my neighbor, that I help to advance the cause of human rights, to advance the cause of justice to people. That's what makes it meaningful to be a lawyer.
Put your hands together, man. Well, so sad that I can go on for another 3 hours, but I can't, Chachu, because our time is sadly up. But I think the case has been made, and I like that conclusion that people should go into their own deep selves and reflect, let their conscience guide them. And I have no doubt that perhaps, you know, a precedent has been set whereby future judges may take another look at this.
Well, it's not only future judges who may take a look. Ultimately, it is us, the people, from whom justice emanates, according to that constitutional principle. So, we as a people, in whose name decisions are being made. And fortunately, these proceedings were aired live, and people were watching, and they were hearing the legal arguments.
Yeah.
And they were hearing, you know, what lawyers on all the sides said, and ultimately what the judges decided. So ultimately, we also have a role in terms of how the justice...
waiting for judges in some future to decide, but as a people,
yes,
we also have a certain role to play.
We do.
In
we absolutely do, and that is why it is also important that, you know, the people cannot be gagged in their discussion of judicial decisions. You know, the people in the media, you know, ordinary people having a commentary, even making T-shirts about the bridge. You can't gag the people in terms of their own experience of decisions of judges. Of course, they must not be insulting, they must not just, you know, do scandalous, say scandalous things and all that. But beyond that, the people ultimately are the arbiters of our own destiny. And we're the arbiters of our own destiny, whether it's to do with judicial decisions or to do with whom we elect. And of course, when we elect, we hope that the declaration will reflect what we elect. But that's part of what the people will continue being engaged with, and nothing can stop that.
Show some love, man. Show some love, man. Oh, my goodness. And on that note, man, I'm glad I put you on the stand because, man,
I was cool with that.
You're cool with being this. You just spoke nothing but the truth. You're free.
The truth shall make you free.
The truth shall make you free. And so, thank you very, very much for your second appearance. I'm sure one time we'll do another third one. I don't know. I'd like to have you and your wife together, maybe one day. I don't know. You're too insane. Who are insanely obsessed with justice?
Well, you know, I think there won't be a box big enough to fit the two of us. But we can try.
We'll try.
We can try.
Okay, folks, we come to the end of Tsatsu in the Box. You heard him, and he came into the box to explain basically what he has gone through and what his interpretation is of the judgment that we have all seen. And he ended on some very, very, very important things, that we are the arbiters of our own future, of our own decisions. And so let's use our conscience as a people, because it is protected in that constitution. Okay, so as we close from Tsatsu in the Box, I want him to declare to the whole nation respectfully that, Tsatsu,
we're out of here.
The KS